Okay, but there's some exceptions, so we'll focus on those, okay?
There are a few exceptions.
And the first thing I guess we can focus on the Green Bay one that you were sent to Green Bay to would you say investigate, or what was your role? Why were you sent
I
to
was sent to Green Bay, and that was in the early 2000s, not to investigate, but just I worked at Oshkosh at the time as a security director.
Okay.
And I was sent there to provide assistance. Green Bay was our sister institution, so I spent about a week at Green Bay while they were in lockdown and examining what had happened at Green Bay and making decisions on what they could do to try and prevent that in the future. That was an instance where an inmate actually made a dummy in his cell. And I wish I still had those pictures because it was remarkable. And it was faced against the back of the cell. He had the sink jimmied so the water continued to run. And it looked as though someone was standing at that sink washing their hands and face from anybody walking by. And then this inmate hid in a part of that institution and waited until, and he cleared at least one, if not two counts. And then he attempted to get up on the roof and find his way out of the institution. He was discovered by staff, and then the institution was locked down. I was called and sent up there to provide assistance at Green Bay while they were in this lockdown and doing the evaluations, and I provided input into my thoughts on what could prevent this in the future.
Okay. And focusing on that event, were there any discipline actions that stemmed from that event?
None that I'm aware of.
Okay. And how about I mean, there's a number of incidents here that you were talking about. Can you identify a time where there was an escape or an attempted escape and discipline resulted?
I know that.
Object, Judge. Discipline isn't an issue in this case. Ms. Novak retired. She was not disciplined.
Okay. What about the investigation start that would possibly result in discipline?
Okay, well then going back, I guess Green Bay, I know, would have had an investigation that could have resulted in discipline. Absolutely, an investigation was completed. Waupun had an escape in early 2000s. I know that there was an investigation of that escape. There would be an investigation anytime there was an escape or attempted escape from one of our fenced institutions.
Well, is there a difference between an investigation, like, for example, a security investigation as opposed to a disciplinary investigation?
Yes and no. I think you begin investigating, and at some point you determine that there may be reason to believe that staff may have done something that would then push you in that direction that we're going to do a staff investigation. But I think initially they kind of start out with we need to do a fact finding and find out what happened. In the Green Bay case, obviously that inmate made a dummy. The staff who made rounds and did counts didn't catch it. The decision would have been made at that point to say it was reasonable they didn't catch it, that the dummy was so good that anyone would have missed that. So we're not going to do a staff investigation and pursue with discipline. At Waupun, I know they did an investigation to determine what happened there. At some point, their administration made a decision that there was at least one employee, if not more, that had failed to do something that allowed this escape to occur. And they did go down the discipline path at Waupun. Memory serves me, it was one correctional officer who was subject to an investigatory and ultimately was disciplined for that. I was a security director at Oshkosh at the time, but I'm unaware that any staff beyond that officer were investigated for potential work rule violations.
Okay, and are you ever aware of a warden being investigated for potential work rule violation in connection with an escape or as a result of an escape?
No.
Okay. Um, is there I mean, uh, is there why do you believe that to be the case, or why do you believe that the Department of Corrections had not investigated wardens for escapes?
Object calls for speculation.
I think we need to have some kind of basis for his opinion.
Okay, well, you said we a few times, or sorry, there was a decision to, after an investigation, if I understood you correctly, there then was a decision to investigate whether there were work rule violations. At what level is that decision happening?
Typically, that would be at the warden level.
Again, based on that answer, I'm going to object to speculation.
Okay, and this is based on your knowledge and
Now,
understanding
if any of these investigations,
as
Mr. Schweikert,
The
Schwackert,
warden is the appointing authority, so the warden would make the decision on disciplinary investigations. That isn't to say they couldn't receive a phone call from someone in central office saying, we've read this report and we have concerns and we want you to do an employee investigation because we believe that there may be grounds for possible work rule violations. But typically, the warden is going to be the one who makes the decision that we're going to do an employee investigation. And often it isn't even the warden. I mean, if an employee's late for work, the first line supervisor is going to start that process. They're going to call the warden and say, should I do an investigatory because John Smith was late to work, and get that approval. I mean, it's for lower level cases that those are begun by the first line supervisor. For an escape, and the warden's going to be involved in that conversation and make a decision that we need to investigate. We need to interview staff. We need to find out if any staff were involved in work rule violations, review the reports, make a decision based off of that report, that yes, there are work rule violations or potential work rule violations, and continue down the disciplinary road.
Okay. And based on your knowledge and experience as a administrator of the adult divisions, do you have any awareness of a warden being disciplined at any time?
I do.
Okay. And are you able to say at what level discipline for wardens is initiated?
I'm not clear what you mean at what level.
I'm sorry, because
who makes the decision that we're going to begin a disciplinary process?
Sure. And what's the title or what's the position that makes that decision?
Well, that would be the administrator, who's the appointing authority, or assistant administrators who work in central office, or similar to a case where a warden may not initially initiate that. The secretary's office certainly could contact the administrator and say, I've read this report and I have concerns, and I want you to do an investigatory interview with this employee and determine whether there was work rule violations. But
okay, I'm sorry, I didn't mean to cut you off.
No, that
okay,
similar process again, where the administrator would be potentially the one who would make that decision to begin a investigatory hearing and determine whether there's work rule violations.
Okay. And so based on what I understood, the warden is the appointing authority at the institution, meaning the person who ultimately hires and fires. Is that right?
Correct, although it's a little muddier because decisions on terminations and hiring are also controlled through central office to some extent. So the wardens don't have the authority to just walk in and fire people. That's in consult with central office,
Okay.
and Bureau of Personnel, Human Resources, and there's a number of steps involved in termination of an employee. It isn't just the warden gets to decide, I'm firing you, you're gone. even though they have that appointing authority, central office has put processes in place where those decisions are reviewed and recommendations are made to the appointing authority on levels of discipline from central office, including termination. Those are through the secretary's office.
Okay. Okay. So, I mean, I think we understand that there's influence, even though they're the appointing authority. Does that sound right?
Absolutely, there's influence. Yes.
Okay. And then above
The warden ultimately signs the letter that says they're terminated, but that's done in very close consultation with the secretary's office, and Bureau of Personnel and Human Resources has a say in those decisions, and we don't always agree. I can tell you that.
Okay, but as warden, there's times when you haven't agreed with the decision, the disciplinary decision, but you've signed the letter as the appointing authority. Is that fair to say?
Correct.
Okay. That is very helpful, sir. Thank you. So let's just talk about discipline here, and because you've, as both warden and as the administrator, you've participated in the discipline of other Department of Correction employees, right?
Correct.
Okay. And are there policies and procedures that govern the discipline of employees?
Absolutely, yes.
Okay. But then, and I also think I also understood there's also influence from administration that governs the discipline of employees. Is that fair to say?
There's processes through the secretary's office as well as the Bureau of Personnel and Human Resources that guide levels of discipline and whether discipline should occur. And those have evolved through the years. Earlier in state employment, the warden had more autonomy. And at the time of my departure, discipline decisions had a number of levels that they went through to determine what level of discipline should be enforced on an employee. And those actually, in many cases, at the time of my departure, were through the secretary's office, as well as through the new personnel department that was created prior to my retirement, had also a say, and records had to be sent to them, and they would evaluate and come back with what they felt was an appropriate level of discipline.
Okay. And based on that knowledge and experience, is it possible for the secretary to have an employee fired directly? I guess
I'm going to object to relevance. We're talking before the policies changed as the evidence, so I'm going to object based on that.
Okay, I'm gonna ask for a foundation, please.
sure. Have you ever seen a secretary cause the termination of an employee?
A secretary cause the termination of employee? Well,
Right.
if we do, so as an example, an employee violates a work rule. The institution does an investigation, determines there's work rule violations, writes that employee up. There's serious work rule violations that absolutely goes to the Department of Corrections central office. That employee is probably out on administrative leave. So while I was employed, and probably continues to this day, employees who are on administrative leave, we met weekly with the secretary's office to determine where we were at in that process, where we were at in the investigatory interviews. At the time when they were completed, that entire packet went down to central office. It went through the administrator's office. It went to the secretary's office. Ultimately, if an employee was going to be fired, the secretary signed off on that termination, on that
Okay.
paperwork. If everyone else thought this isn't that big of a deal, we think that discipline could be handled at a much lower extent, and it went to the secretary's office, and the secretary said, I totally disagree, and I want this employee to be terminated, that employee would be terminated unless there was outside external forces that would act upon. In the case of Bureau of Personnel Human Resources or something else, that employee was terminated based on the secretary's decision. We may not agree with that decision. We may share with him what our thoughts are on that decision and let him know that we don't feel we're going to be sustained in the long run. But if the secretary said, I want this employee terminated, they would have been terminated.
Okay.
Without some external force acting upon them, that employee would be terminated from the Department of Corrections and they'd have their appeal rights.
Can you explain what you mean by external force?
Well, at the time of my departure, the Bureau of Personnel Human Resources was involved in decisions on discipline. I don't know what they're doing today, but they could have said, we disagree with your decision and we don't want to terminate this employee. If the secretary pushed it vehemently, ultimately, I guess the secretary would probably win out in those cases because it's his department and he has to run it the way he sees fit.
Okay.
And you'd get into a point of, you'd have a secretary of two departments arguing over something, and corrections secretary in a termination case would probably win out on that. What happened more likely, and what I can share with you, is the department didn't believe a level of discipline as great was necessary. And the personnel department disagreed and felt discipline needed to be at a higher level. That was more often the case, but it can go either way. There were cases where the secretary's office actually pushed
excuse me.
for terminations.
Well, I appreciate Mr. Schwackert's walk through history and policy. I think we need to get more focused on the timeframes of this case, the specifics of this case, which did actually not include discipline, but an investigation. So if we can get his knowledge about anything that is actually happening in this case, as opposed to history, I think that's where we need to be.
Okay. Well, I appreciate that. Besides the history lesson, that explanation of how things actually work at the Department of Corrections, as opposed to.
They did as when he worked there. We don't know what they work, how they work now.
Do you have any reason to believe, sir, that the Secretary of the Department of Corrections couldn't terminate somebody today if he wanted to?
Objection, speculation.
Sustained.
So let's go into and just remind us when you retired.
I retired in January of 2019.
Okay. And that's the same time that Secretary Carr took over, right?
He, yes, was appointed. Our paths never crossed. Kathy Jess was secretary. On the last day of our appointments, I was appointed as administrator. She stepped down, all of us stepped down, and the new team stepped in.
I got it. So, because you were succeeded by Magda Fesahayi, right?
Correct.
Okay. So let's talk about, have you ever, based on your knowledge of the discipline process, how are work rule violations communicated to employees?
I would object again. We've already established he can testify to what the process was when he was there, but not what the process is now or back in April 2020, which is what is relevant in this case.
I think we need real knowledge about what this is, and so unless he can give us that information. I thought you were calling him so that he could tell us about people who were investigated and disciplined for jail breakouts.
No, we're trying to get him on what his knowledge of constructive discharge at the at the department is. So we're trying to find out what he knows about how the message is communicated to employees and what their response is and why their response would be that response.
But that would have been from prior to this administration. So I'll give you a small amount of time, but I'm not going to spend a lot of time because I don't know.
Well,
If these
Judge, the
changes have
Constitution
occurred.
hasn't changed since then. Loudermill hasn't changed since then. It's not like, I mean, this is,
I don't know what the policies are. I don't know if there's been any changes. The state goes through changes. Sometimes they don't change forever, and then sometimes they have
but
big
you're
changes.
assuming then, in the absence of any evidence, that the policies have completely changed from one day to the next.
I have no
That's
idea,
profit
and that's what you
bias
need
right
to
there,
prove.
Judge. That's what that is.
No, that's what you need to prove to me. If he's going to testify and you say it's valid, then you need to show me that his testimony is still valid because there has been no changes. That's your job, not mine.
Well, again, it's the assumption there that they have changed, as opposed to, which is also, then it's the assumption that's built into there that the moment that this man left, that for the rules for employment in the state of Wisconsin suddenly changed. And
He
that,
left in 2019 of January when new administration and new people came in. And then the events of this case took over a year later. So I don't know what happened in that year time. So again, I need to know that what he has to say is relevant because we've been talking to him quite a long time. And he's been
That's what I'm
talking
saying.
about a
You're
lot of things
assuming
that
that
went
there's
on
a
for
fact.
30 years before this happened.
you're assuming that the fact is that they've changed the moment that he left, as
No,
opposed
what
to
I'm saying
assuming that
is I don't
that they've been
know.
continuous through, okay.
No,
Right,
I
so
don't
that's
know.
again, because you don't know, you're saying that you're assuming that they've changed, again, based on Mr.
Assuming
Novak's
that you
testimony.
should put on relevant evidence that actually shows me what happened today, as opposed to telling me what happened in the past, unless you can prove to me that what happened in the past is the same. Your primary duty is to show me what happened in the current situation, not what happened in the past. So I'm willing to let you have a little
Okay.
bit of time on this with this person, although we've gone a lot of time with this person. And I appreciate Mr. Schwackert's information, but it is not getting us to what we need about this case. So please try to focus on what we need for this case in this time
Okay,
frame.
again, we've got that objection on the record on that again, there's an evidence of bias because there's an assumption there that the moment that he left, that you've just explained, that you have prejudged this case, that the moment he left, all of the policies at the Department of Corrections changed.
And
so
that is not my assumption. What I'm trying to
That's
say is
precisely
you
your
need to
assumption.
have people who can talk about the time frame of when these things happen, because I don't know what that situation is. And unfortunately, neither for you does Mr. Schwarkert know either, unless you can establish that he has a base of knowledge. So go ahead and ask some more questions, but again,
Sure.
at
Again,
some
sir,
point,
how
we're gonna
long have you
stop.
been employed were you employed by the Department of Corrections?
Over 33 years.
Okay, and how long were you in upper management?
I, I'll put a line in the sand and say a career executive position. I began in 2001 as a security director and eventually left in 2019 as division administrator.
Okay, and during that time, was there how many changes in policy were there regarding the separation of employees?
There were small changes that occurred, processes. Most of those changes surrounded input from external forces. New work rules were created after Act 10. But other than that, processes changed very little during that time. The
Okay.
disciplinary process is all based on case law and processes, so it.
Okay, and at any time or during your career, it was your understanding that it was the secretary that was in charge of the Department of Corrections? Did that change any time?
No, never changed. Well,
Okay.
when I first began, we were a division and became a Department of Corrections in 1990, but we still had a secretary even prior to that. It was just for a different division.
Okay, and during the entire course of that time, it was the secretary that was in charge of that Department of Corrections, right?
Correct.
Okay. Now, again, based on your knowledge and understanding of the policies and procedures for terminating employees, we're going to prior to any discipline being based on a work rule violation, there needs to be an investigation into a potential work rule violation. Is that right?
Again, Judge, I'm going to object. He's not testifying as to what the rule was now or what the rule was in April 2020. I don't see how this is relevant.
Okay. So, Mr. Mullenbach, are you telling me there was a rule change from the 2019 in disciplines and now?
Yes.
Okay.
Wow.
All right. So, Mr. Cross, Mr. Schwackert, are you aware of any changes in the disciplinary policies that occurred after your the termination or that you retired from your employment? Sorry about that.
No.
No. Okay.
No, I'm unaware of any changes. I'm certain that policies were tweaked. They always are, but probably
would you
not
have
major
any
changes
basis
because
of
that's all
knowledge?
covered by case law.
And would you have any basis for knowledge of this, of the standards for discipline and the process that occurs after you left?
No, I would not. I retired and happily retired.
Okay.
Haven't kept up on those processes.
Okay, then as far as I'm concerned, he's telling us that he doesn't know for sure what happens after he left in 2019.
Hey, Judge, the Department of Corrections discriminated against my client in terms and conditions of employment. Are we done now?
No, I don't know what I'm telling you, you just have to prove your case. Mr.
Right, and I'm saying, hey,
Cross.
you just allowed Mr. Mullenbach to testify.
I asked him if he was
you
his
assumed the fact that he
objection.
just said, which was he said there was a change in the rule, and I'm saying, okay, great. Well, let's have the same standard for us. So I just told you that our Department of Corrections discriminated against my client. So now I'm assuming you'll give me the same courtesy, assuming what I testified to is true, and then let's be done with this case.
Okay. My position on that was that I was trying to determine if there was a basis for his objection that was based on anything real. Mr. Mullenbach, are you going to prove that there was a difference in change in the policy?
I do plan on calling a witness from HR who I anticipate will go over all of that. That is the purpose of my calling her, yes.
Okay. And that's the purpose. I would like to hear from that person because that's the person who knows what's going on at the time of this, that this actually happened. Okay, I let you go on with him and I'll still let you go on a little bit longer. But again, we aren't hearing for sure that he has any knowledge of what happened at the time. And I think we heard from Secretary Carr yesterday, it's clear from him that he did have the authority to terminate someone if he made that decision after listening to the investigation. He said that he gets to make the final decision. So I don't think there's any question about that.
This man said, but so now we're all wasted the last 20 minutes because Mr. Mullenbach was allowed to testify that there is somehow some change. So now we've had to go back and establish that there isn't change.
Just do the darn thing. Just do it, Mr. Cross. I don't see that this is helpful to us, but if you want to go and waste our time, you can go right ahead.
Put on the record there that you knew this fact to be incorrect. So that's just problematic there because you're prejudging, but in fact, not only are you prejudging, you've got facts that you know and said now that are on the record that you know that the policy has continued from what this man said here to what the secretary testified to yesterday. And so this is an artificial cutoff and an unnecessarily heavy-handed approach to evidence, as you've been warned about.
Did I not just say I was going to let you go on and spend more time on this, which I don't see as helpful, but I'm going to let you.
That's why we have
so you go right ahead, clear. And we'll see how very helpful this is.
I appreciate that.
Which is not going to be very helpful, I can tell you.
Okay, so let also the record show that the judge just made a semi-sotto voce comment in which she already prejudged the rest of this man's statements, saying that they weren't going to be very helpful. So I'm not clear why we're going to waste any more of this man's time, Judge. Can you explain to us why we're going to bother to have him testify anymore, since you've already told us that
I'm open to hearing what he has to say, and maybe he will tell me something, but so far he has not told me anything that's going to be helpful to me, unless, at least, I mean, generally it was very helpful. But I need now, after you spent all this time, to get to more specifics about what's happening in this case. And that has not gotten there.
Right, with a prejudged artificial cutoff that you've been warned about by alert.
Again, just start.
I think we've communicated then. All right. So now, when have you ever, I guess this is the thing that I need to understand is, have you participated in
Can
charging?
we at least focus on his end of his employment and the point, what he was doing and the processes at the end of his employment? So at least we know that that was what was going on when he left, not any changes or things that happened a long time ago. Can we focus on the last?
Sure. So when you hear
Mr.
my
Zappa's appointment?
prefacing my question with, as based on your knowledge and understanding of the administrator of the adult division, then we, based on his prior testimony and foundation of what time that is, then we are able to then narrow that down in time.
Okay, that's good. Thank you.
Great. Okay. So, sir, the question that I'm ultimately going to try to get to here, so I guess we'll just have to telegraph it, is that what is the message sent to an employee when they are charged with a work rule violation? Okay, so let's start out there. Have you participated in the charging, for lack of a better word, of a DOC employee with a work rule violation?
Correct.
Okay,
As an administrator, we're talking about when he was division administrator.
right. When you were a division administrator.
Correct.
Go ahead.
Okay. And based on that, there's a preliminary step that's an investigation meeting or something like along those lines.
A pre-disciplinary meeting, yes.
Okay. Who takes part
An
in that?
investigatory and a pre-disciplinary. Investigatory occurs first, and then based on the results of that interview, a determination is made whether a work rule's been violated. If a work rule's been violated, then a pre-disciplinary interview is held to allow the employee to answer to that. And after that, all of those are communicated to the employee in writing. After that's completed, then pre-disciplinary, then a decision process is in place where the appointing authority determines level of discipline.
Okay. Now, let's be clear that although there is a progressive disciplinary process, the management is ultimately able to impose discipline based on its criteria, right?
Correct.
Okay. So,